At first glance, this looked like just another routine courtroom hearing. But within minutes, a defendant on probation would admit to violation after violation, missing reports, unpaid fees, ignored court orders, and even new criminal charges. What started as a simple roll call was about to reveal a long list of mistakes that could change a life forever.
Good morning. Are you Christopher Fair?
Yes, ma'am.
And this is 18-30684. Mr. Fair is on probation for indecency with a child by sexual contact. There's a motion to revoke that's been filed. And what is the announcement?
Judge, at this time, we're prepared to plead with the truth for several violations.
Okay, just go through and set up the
Right.
hearing. Give me just a second. And will he waive the formal reading of that motion?
He does.
Mr. Fair, best you can, please raise your right hand. Do you swear or affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yeah.
So, Mr. Fair, I have before me a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation December 2nd of 2019 for the second-degree felony offense of indecency with a child, and that was a 10-year deferred probation. Is that correct?
Yes.
It alleges that you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
True.
Count 2 alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
True.
Count 3 alleges that you failed to successfully complete an approved sex offender treatment program by a licensed sex offender treatment provider. Is that true or not true?
True.
Count 4 alleges that you are behind in your court assessed fees as of December 9th, 2025 in the amount of $3,290. And is that true or not true?
True.
Count 5 alleges that you failed to immediately report to the probation officer your phone number, employment, and that you now have an email. And is that true or not true?
True.
Count 6 alleges that you failed to report by mail or online to the Jefferson County Probation Department for the months of February, March, May, June, July, August, September, October, November, and December of 2024. And then January, February, April, May, June, July, August, September, October, and November of 2025. Is that true or not true?
True.
Count 7 alleges that you committed the new offense of possession of marijuana January 21st of 2026 in Walker County, Texas. Is that true or not true?
Not true.
Count 8 alleges that you committed the offense of unlawful possession of a firearm by felon January 21st of 2026 in Walker County, Texas. Is that true or not true?
Not true.
Count 9 alleges that you committed the offense of possession of drug paraphernalia January 21st of 2026 in Walker County, Texas. Is that true or not true?
True.
Count 10.
Listen carefully to what happens next. One by one, the defendant admits that most of the allegations are true. Every answer pushes him closer to disaster. And by the time the judge finishes reviewing the violations, the future of his probation hangs by a thread. This is the moment where every word matters.
Alleges that you committed the offense of failure to drive in a single marked lane January 21st of 2026. Is that true or not true?
True.
Count 11 alleges that you committed the offense of having no valid driver's license January 21st of 2026. And is that true or not true?
True.
And count 12 alleges that you failed to immediately report to your probation officer that new arrest. Is that true or not true?
True.
Did you enter your pleas of true? See, the easier way to do this. Did you enter your pleas of true to all of the counts except 7 and 8 freely and voluntarily?
Yeah.
And did you plead true to those counts because they're actually true?
Yes.
All right, then I'm going to find that you entered your pleas of true to all of the counts except 7 and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. But I'm going to reset your case for a hearing. Ms. French, do you anticipate that you would try to get anyone from the county to prove those allegations of 7 and 8, or just go forward on what he's pled on?
I think we can go forward on the 10 he's pled on.
Okay. So then we'll get an updated pre-sentence report done. Anything that you think is important for me to know, make sure you get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. All right, and go back with the bailiff.
Good morning, Judge.
Good morning. Are you Jimmy Cal?
Yes, ma'am.
Y'all give me just a second. I don't know.
We're gonna wait his statute. We can know that it's attempted. Yes, we are.
That's coming. Mr. Couch,
Yes, ma'am.
pay attention this way. All right. Will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Couch, in clause number 26, DCCR 0328, the state has elected to proceed on the lesser included offense of a third-degree felony, attempted burglary of a habitation. And that's from January 29th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 3-year deferred probation. There will be a $500 fine. You'd be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Oh, yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Couch is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. Ms. Malfino?
Judge, the state would respectfully object to any type of PSI bond in this case because of the fact that we're going to very strongly urge the court to consider safety. I have met multiple times with the complainant, Ms. Couch, in this case. She is actually present in court today. I think there is an underlying severe substance abuse issue that has contributed to all of these issues, and that will be the position.
These cases prove a powerful reality about the American justice system. Sometimes a single bad decision leads someone to court, but repeated mistakes can completely destroy a second chance. As this hearing comes to an end, one question remains. Should the court continue giving opportunities, or is accountability the only answer left?
Position of the state to ask for safety, and I'm afraid that if he's out in the interim, it will derail that and also his absence of contact with her at this point.
So,
I understand that's the state's position.
Sure.
Mr. Couch is requesting that you do consider allowing him to be released. He's been in jail now for
4 months.
4 months. He's getting some taking AA classes in jail.
From Rocco.
He's got some health issues that he desperately wants to get on the outside and
Yes, ma'am.
addressed.
I have a spot on my lung. I was supposed to be in Baptist Hospital for another PET scan and another biopsy. And it's just getting worse by the day.
well, if Mr. Rojas, if you want to get some information to the court between now and sentencing, I can bump something up with regard to a bond hearing. But today, based on the allegations and the concern, what I'm going to do is not change the bond. I am going to ask probation to do go ahead and get a substance abuse assessment during that so that we have everything in place when we come back for sentencing. All right, you can go back with the bailiff.
Okay, thank you.
Good morning. Are you Bragan Fuelsman? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hulsman, in cause number 26, DCCR 0199, The state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that's from January 7th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for, hold on, it's back. A 2-year deferred probation. There would be a $250 fine, and you would be required to follow all of the rules and conditions of probation. Part of that would be that you would follow any recommendations with regard to any mental health care issues. Do you understand? State tenders number 1.
No objection.
It's admitted. And are you a U.S. citizen? All right. Is there any evidence that Ms. Hulsman is not competent?
None that has not already been addressed, Judge.
Okay. All right, then, Ms. Hulsman, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of the plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $250 fine, and you're ordered to follow all of the rules and conditions of probation, including any mental health care. If you do all of that, this is a great opportunity because you won't have a conviction on your record. And at the end of the probation period, if you successfully complete it, the case is dismissed. The other side of that is if you violate any condition of probation, you can be brought back in the court and you could be convicted and sent to our Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You'll get some instructions from probation today so that you'll know exactly what to do when you're released from jail. Make sure you do all that, okay? All right, you can go back.
They did do their purpose.
Good morning. Are you John McMillan?
Yes, I am.
And this is cause number 26 DCCR 0517. I'm going to take judicial notice of the court's file. There was a request and Mr. McMillan was evaluated for competency to stand trial. Dr. Krapon provided a report dated May 29th of 2026 with the finding in it that Mr. McMillan is currently competent to stand trial. Any other evidence with regard to competency?
No, Your Honor.
No, Your Honor.
All right, then at this time, I am going to find Mr. McMillan competent to stand trial. And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Judge, with the court's permission, may we proceed on the lesser included Class A assault on this, just so the court knows I have sent multiple letters with lack of response. That's the reason for the law.
All right, thank you. So, Mr. McMillan, again, in cause number 26, DCCR 0517, the state's elected to proceed on the lesser included offense of a Class A misdemeanor assault. And that's from March 8th of 2026. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. All right, Mr. McMillan, I'm going to find that you entered your plea of guilty freely and voluntarily. Again, I made that finding already, that you're competent to stand trial and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor assault. Sentence you in accordance with your agreement to a term of 9 months in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal.
Yes, Your Honor.
All right, good luck to you, sir.
Thank you, Judge.
Thank you.
Thanks for watching and subscribe my channel.